Okay, ladies and gentlemen, we're going to get started. Welcome all of you to Tiller House, the headquarters in DC of the American Society of International Law Research here at ASIL. For those of you who might have not of what the society is, talk a little bit about some of the things I wanted to highlight, and then I'll turn things over to our moderator, Christy, today. The Society is a 108-year-old professional membership association. It's primarily international lawyers, but it's actually comprised of a lot of other science, librarians. As international law has grown in the context of globalization and its impact in the rest of the world, there are quite a few other disciplines that have found that being a member is very valuable. We are a nonprofit, non-advocacy, non-partisan group. So we do not take a stand or a specific stance on particular issues. Our focus is on providing education and information to constituencies about international law issues. That's everyone from high school students and the general public all the way up to international judges sitting in international courts and tribunals and members of international organizations. We work with everyone in between, from people who have never dealt with an international law issue before to people whose entire careers have been built around this. We also address every single topic that you can possibly think of. So our interest groups, which are kind of like subcommittees that focus on specific areas of international law, range from private international law, international economic law, international law and trade, to international human rights, international humanitarian law, environmental law, law and technology, the law of the sea, space law, anything that you can, national component. We have people who are not just interested, but they're probably the experts in that field. We also have several demographic interest groups that are focused on either geographic regions or specific areas like new professionals and students. Tonight's event is co-sponsored by the Women in International Law Interest Group, of which Christy Edwards, our moderator, is a co-chair. So we're very pleased that they were able to put this together, and we're very pleased to be able to host this wonderful event. I did want to flag, for those of you who are in the area, we have two events next week that might be of interest. Next Tuesday night, there is an event specifically for students and new professionals interested in careers in international trade and customs. So you're more than welcome to come to that. It's open attendance, so we'd invite you to join us for that. And then Thursday night, we have an event that is being co-sponsored by GW Law School and the Swiss Embassy here in DC. Their foreign ministry legal advisor is going to be coming and joining the International Committee of the Red Cross to talk about international humanitarian law trends, specifically looking at voluntary compliance issues in conjunction with the Montreux Doctrine about private military contractors. So that's going to be a very exciting discussion. And the Swiss Embassy is bringing for some really good reception stuff. So you can join us for that. Outside of that, I did want to mention we will have some materials that you can take with you afterwards, both about ASIL membership if you're interested more in the society, and I believe Dr. Gallagher has some materials about her books that are very on point for this talk to pass out as well, so we can make those available. If you have any questions during, we will have a chance for questions at the end. We are being live streamed, so for those online, you can send questions to events@asil.org, and I will have the ability to check this. There's information about live tweeting the event tonight. You can use the hashtag HT. That's ASILHT to welcome you guys participate.
Thanks so much, Wes. Can you... This is actually more for
over to Chris.
I'm so making as after for the American Red Cross. Just we'll definitely leave plenty of time. Questions from we go through a few one I won't go through their
different phenomena, but that have distinct overlaps. So trafficking, well, we could talk about the definition of trafficking for such a long time, but basically we're talking about moving or maintaining people into a situation of exploitation from which they can't escape for any number of reasons. That's a very abbreviated definition. I think Janie and Dina could add much more to that. Migrant smuggling is the movement of people across an international border illegally for profit. So it sounds quite different. And I think that when states came together and developed two parallel legal regimes, they wanted very much to maintain the distinction between the two. But I think one of the things that the last 14 or 15 years have taught us since those two instruments were developed is that there's the overlap is actually very great. Someone can be smuggled one day and trafficked the next. We know that many people who have paid for facilitated migration end up in situations of exploitation. And I think that the last couple of years in particular, where we're seeing large movements, for example, from Southern Africa up to Europe, the overlap has become more and more marked. And we're starting to realize that the distinction between trafficking on one hand, where it's considered a human rights issue and victims of trafficking are entitled, at least in theory, to certain protections and entitlements under international law. The distinction between that regime and smuggling, where those who are involved are pretty much considered complicit in their own misfortune and left to their misery, actually is perhaps not the best way to go. But I think it's in the interests of many states to actually maintain that distinction, so I don't see that it's going to be broken down anytime soon.
Great, thank you. Professor Haynes, did you have anything you wanted to add?
Yeah, just briefly, for those people who are living in the US, there was a cover article in the New York Times last week about a child migrant. So you may have heard about the unaccompanied child migrant issue recently. And the story, which was quite long, and it was interesting that it was a cover story for the New York Times, followed a young woman who was, I believe, 14, who had, well, the title of the article had smuggling in it, and nowhere in the article was anything about human trafficking mentioned. The whole article was about smuggling. But shortly after she crossed the border, she was basically subcontracted out to multiple smugglers, each one who demanded a higher price, and ultimately were demanding it from someone who was a friend of a family member's employer, somebody tangentially related. And there was either an implicit or explicit threat that if the fee wasn't paid and that the fee was increasing with each subcontractor who was moving her, that she would, horrible and foul things would befall her. So it was interesting to me, I mean, and that maybe starts out as smuggling and quickly morphs into human trafficking. That seemed to me to be, at least with my lawyer hat on, if I were representing her, a prime example of that. But the article didn't characterize it or suggest that it could possibly be trafficking. And similarly, there was another article just in this month's issue of The New Yorker about Chinese restaurant workers in New York from the Fujian province. Same thing. The fee paid to a smuggler to come is $70,000. So I've written about this before with one of my clients, but one of the issues that she faced, which wasn't explicitly stated in this particular article, was that if you don't pay that fee back, there are threats, not just to you, but to your family members back home. So again, in my mind, you know, even though the article was about these plucky people who go into the restaurant industry and try to improve their lives, as soon as there's that exploitation and threats for payment, there's a sort of debt peonage that takes place, and it could quickly morph. So I guess my response would be to just think about when you see things characterized one way or another, especially if you're lawyers or in law school, how you could argue that it become trafficking as well.
That's so interesting, because we have talked about the issue of forced laborers under trafficking for a long time, but since those distinctions are not being made necessarily between migrant workers or migrant smuggling once they become forced laborers, that's a very interesting distinction. And I'm getting the signal we might need to speak a little bit closer into the microphone so that people can hear us online or in the back of the room, since we've got more people now. So again, Dr. Gallagher, in your experience or in your research, to what extent has international law made a positive contribution to ending trafficking and smuggling-related exploitation?
Gosh, thank you. Another good question to get rid of my jet lag. I'm actually, I think, much more optimistic than perhaps many advocates. I'll talk a little bit about trafficking, because I think that normatively, trafficking has really come ahead in a way that migrant smuggling actually hasn't. But I guess that this is part of a product of me working in this area for so long and remembering a time back at the United Nations when I started working for the UN in the early 1990s, when so many of the issues that are now under the umbrella of trafficking were just completely off the radar, or at least they were at the edge of the international human rights system. So back in, 1992 or 3, when I started at the UN, yeah, I think it was around about then. Things like forced marriage, violence against women, even forced labor, that was relegated to the ILO. The international human rights system had absolutely nothing to do with that. Sexual exploitation of women and children. These issues just were not on the agenda at all. the mainstream human rights system was dealing with torture and civil and political rights and a few economic, social and cultural rights, but they just weren't interested in any of this stuff. So if we look back then and jump forward 20 years, then I think we can see a significant difference. We have an international legal instrument now that doesn't just define what trafficking in persons is, but also sets out in considerable detail the obligations that states are under with regard to identifying victims of trafficking, criminalising trafficking, kind of protecting victims, although that part is a little bit weak, and cooperating with each other to develop effective criminal justice responses around extradition and mutual legal assistance and all of those technical kinds of things that at the end of the day actually are extremely important. And we don't just see that, we also see that at least at the level the law is much better, but also at the level of policy. We see a lot of attention to human trafficking these days. I'm sure everybody here is well aware of what the State Department does with its annual reports on trafficking in persons, which make a lot of countries in the world very unhappy. But I feel a bit ambivalent about those reports, because even if they're kind of insulting on so many levels, and I also worry very much that they don't take as a clear measure the international legal standards around trafficking, but they use some kind of US version of that. But I do see in my work on the front line with criminal justice officials in Southeast Asia, which is that's my day job, that without the external pressure from the US tip reports, lots of things that in the end are good for victims of trafficking and good for vulnerable groups in society actually wouldn't be happening. So yeah, I'm a bit of a Pollyanna when it comes to trafficking, human trafficking. I think that we have now a pretty robust international legal framework around this issue, and we have, at least in some respects, we have a measure of political momentum that means that the gap between the law and the practice is perhaps closing ever so slowly. Now, migrant smuggling is something very different. So my book on migrant smuggling is actually thicker than the trafficking book, and I can talk about that in a minute. But an international legal framework around migrant smuggling was developed at the same time as the trafficking protocol, and in pretty much every respect, these are identical instruments. They kind of look the same, they have similar sorts of obligations, but their level of, and there have been significant ratifications. The trafficking protocol, I think, has been ratified by or acceded to by more than 160 states, and migrant smuggling is a little bit less than that, but it's still fairly impressive. But definitely around migrant smuggling, states are just much more ambivalent, and they've been very reluctant to actually give the migrant smuggling protocol the kind of profile that the trafficking protocol has been given. I just came from Vienna. There was the meeting of the conference of parties to the Organised Crime Convention and its protocols last week, and it was very telling how nervous states are about even paying too much attention to the migrant smuggling protocol and to the obligations in that. And I think this comes back to my belief that states were, because of everything that was happening around trafficking and the realization about the levels of exploitation that people were suffering, states were ready to make small concessions for a small group of people, but they're not willing to actually take the kind of step that would allow all those who are vulnerable to exploitation and all those who suffer from exploitation to actually benefit from that. And that this is where we see the distinction between the migrant smuggling regime and the trafficking regime.
Great, thank you. Professor Haynes?
I'm more cynical. I don't know. I'll just give a short answer and people can talk to me about it after if you would like. But I think that with regard to both of them, unless and until countries are willing to see a greater cost to labor exploitation than they are to the economic benefits that come from it, there won't be any significant changes for either. I mean, we'll have the laws, but with regard to implementation, we'll see retrenchment repeatedly. Well, with regard to to carrying out those laws, and we still see it quite a bit. I think that we've, on the one hand, in countries like the U.S., had plenty of time to focus on awareness, and we should be beyond awareness at this point. And then I see examples where, thanks. Thank you. I see examples where the ability to recognize somebody has gone completely missing. So on one hand, I think awareness, we've done enough on that, and we need to move into implementation. But on the other hand, I see that still key players like law enforcement officers, for example, are still missing trafficked people. We're still unable to see them for whatever reason. And I have opinions about why that is, but it doesn't really answer your question, so I'll leave it for later.
I guess I have a follow-up question to the last question that I asked, and I'm curious, as you speak, whether or not you think that both the trafficking and the migrant smuggling laws adequately address the gender dimensions and specific needs and experiences of both men and women in these legal frameworks.
Who's going to take that one?
Sorry, I sprung that one on you last minute.
Well, you know, I think we can have a long discussion about the gendered nature of international law, and I think that these newer laws aren't necessarily terribly much better than their predecessors. The trafficking, I was at the negotiations for the Trafficking and Migrant Smuggling Protocol at the UN from 1998 to 2000, as was Janie. And just about everyone actually developing the laws, those who were negotiating within the drafting groups, they were all men. And it was women who were the small group of NGOs running around and trying to make sure that these laws, which were being developed outside the international human rights framework, which is, I think, another very interesting issue, I actually think, but we can talk about that a little bit more later. Yeah, so I think it's reflected. There's the trafficking protocol is actually the protocol to, you know, suppress trafficking in persons, especially women and children. So they got it all right in the title, but in actual fact, when one goes through the text, there's very, very little in the way of any kind of appreciation of the gendered nature of trafficking and the highly gendered nature of how states respond to trafficking. And I think migrant smuggling is even worse. But that for me reflects generally laws around labour exploitation, forced labour, migrants' rights. They're all, very poor on that front. And maybe we see some, once again, I'm probably going to be more optimistic than you. And I can look at my practice once again in the field with criminal justice officials, and we are seeing changes. We're seeing, I think, one of the greatest advances gendered response to trafficking has been actually the recognition that men and boys are also victims of trafficking, which has switched the focus, or at least pushed it very, very slightly over towards trafficking for labour exploitation at the expense of the previous exclusive focus on trafficking for sexual exploitation.
Absolutely. Did you have anything else you wanted to add?
Just that I think that the gender blinders are part of or the gender stereotypes that we have are part of what's obscuring our ability to see certain trafficked people. Because, for example, the bifurcation between labor and sex trafficking has a real gendered dynamic to it, so that, for example, a woman who has been trafficked in to work in the restaurant industry, for example, is unlikely to be recognized for that unless she says trigger words about sex trafficking. And we are certainly more aware of men and boys, boys in particular, in sex trafficking. I'm not sure that we've made strides in utilizing that knowledge to help us make large advances in how to assist.
But if I can just add one thing to that, and that is an observation without real analysis or comment, about the gendered nature of people who are interested in trafficking. So whenever I work with, as I said, my day job is in the criminal justice sector. So I work with police and prosecutors and judges. So I work almost exclusively with men. And this is Southeast Asia, so it's like that. But when I'm working in other countries in this environment, it's almost always men. And a lot of the work that I do at the international level, at the UN, there is also, in some settings, particularly when trafficking is considered in the context of organised crime, then it's men again. But if ever I'm talking about trafficking or teaching about trafficking, it's predominantly women. So I haven't worked that through. I haven't really thought about why it's actually like that. But I think it's not just the gendered nature of trafficking isn't just in relation to states and their response to trafficking. And even in scholarship, once again, if you have a look at the scholarship around human trafficking, it's heavily, heavily dominated by female scholars. I don't understand that, but it's interesting.
Yeah, you're absolutely right. So other than the gender dimensions, what do you think are some of the critical gaps and weaknesses, and how can these be addressed?
Oh, okay. So this is where I get to be really negative. And it's not really very hard because the last couple of days, so from Monday and Tuesday of this week, I was chairing a meeting in Vienna at the UN Office on Drugs and Crime. And it was, we're doing this multi-year study of the problematic aspects of the definition of trafficking in persons. So we're looking at, I'm sure, I don't know if all of you are across the definition, but it's got things in it like abuse of a position of vulnerability as a means of exploiting someone. And it says consent is irrelevant if any of the means like force, fraud, coercion, abuse of a position of vulnerability are used. And it also says that, all of this happens, like the purpose of trafficking is exploitation. And it doesn't define exploitation, it just says exploitation includes this, 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 and this. So anyway, where I've been leading this research that's looking at these problematic aspects. So this is this was launched last week. This is a study on how states are in understanding and applying the principle of the irrelevance of consent of victims. So basically it means that if a victim says, no, I'm fine actually, maybe my situation is even better than it was before, that actually shouldn't, if the other elements of the crime have been made out, then that shouldn't make a difference and it should still be trafficking. Sorry, so this is a very long way I'll leave that for people to look at.
Actually, what's the name of the report so the folks online can
Oh, okay, so it's a UNODC issue paper, The Role of Consent in the Trafficking in Persons Protocol. It's online now, and the previous study on the concept of abuse of a position of vulnerability in the definition of trafficking in persons, that's also online. And the third study, which is on the concept of exploitation, I've just finished, and it was subject to an expert group meeting last week, which is a meeting I was talking about. But sorry, to get back to your question about challenges, I have to admit that I did have a moment during that meeting when I was faced by the representative of a Middle Eastern country that I think from any objective measure has terrible, terrible problems of trafficking. And this very senior representative looked me squarely in the eyes and he said, we don't have exploitation in our country. So I think there's a lot of denial on the part of states as to the nature of the problem, and in a way we can understand it, and Dina alluded to it. It's just a fact that human exploitation has built our world and it keeps powering global economic growth, and states are pretty quick to talk the talk, but in fact many countries actually benefit enormously from a level of exploitation within their migrant worker populations. I think even countries that send their workers abroad, the remittances that come back prop up some pretty unsavory regimes sometimes, and they have a vested interest in shutting up, and they might bleat a little bit at the United Nations, but at the end of the day, they're not really going to make the kind of noise that would actually stop their nationals being exploited in this way. So I guess the biggest challenge for me is the superficiality of states' commitment to trafficking. And I think, unfortunately, the US, while it's actually managed to push the issue at the international level, have also created kind of it's very difficult to explain, but I think countries are getting good at giving the Americans what they think they want. And in fact, it's actually not very much. It doesn't, as Dina said, it doesn't address the kind of structural issues that are fundamental to how exploitation happens and how it continues. Sorry, long answer to a complicated question.
That's very helpful. Thank you.
Just briefly, clearly the example that Anne gave is worse when a head of state says there's no problem in his country. But so I feel a little bit bad calling out a country that's attempting to address something. But I think that when the US or other large donors have given out funding, we have a responsibility to make assessments, better assessments about how that funding is being utilized, because I don't think it's necessarily a win-win. I think that harm can be done with bad funding, not just to the people who aren't being assisted there, but also to the larger issue about where we should be directing our attention. I'm not sure that's the largest problem, but I think it's a problem that we're squarely in right now at this stage. And I also think that more lawyers for victims in countries that have legal regimes that allow some kind of immigration assistance or victim civil damages or even restitution through criminal prosecution. I think really victims need to be represented by lawyers separately in those three processes, because being treated solely by law enforcement as a witness for prosecution is antithetical to that individual victim's potential claims, and we're not addressing that right now.
Thanks. Dr. Gallagher, you mentioned, or actually both of you mentioned, the effectiveness of the US government response. And I'm actually really curious, particularly with the TIP office's, the 3P approach, and whether or not you think that the prevention prong of that is effective, and what are they doing well, and how could they be making a better contribution to these issues?
I'll just respond to that fairly quickly, because I think Dina's very well placed to pick up on that. I think I've already said that I've had a little bit of a change of heart when the TIP report first came out in 2001. Was it, Janie? I wrote a review of the report, and it was very easy to do because the report was so terrible that it was kind of like massacring a kitten. But nowhere near as cute. But it wasn't very difficult to pull apart this. It just had no methodology, and it set itself up like it was all puffy in the beginning, and there was just nothing there. So anyway, but as the years went on, I think the reports got much better. And the thing that made me realize their importance was when the UN put out its report, its global report on trafficking in persons, which, because the UN could only receive information from countries, it told us nothing. And then I thought, well, considering the fact that there's no other options out there, perhaps the TIP report is better than nothing. And I've also seen the impact on the ground. I know that the countries that I work in wouldn't be reforming their police systems. They wouldn't be setting up shelters. They'd be keeping victims locked up in shelters. All of these things would be continuing, and they still do to some extent, but there has been that overall positive influence. But then, of course, some of the problems continue. The methodology is still pretty weak, and unfortunately the TIP report has sort of become a launching pad for just about everyone with an office and a computer to set up their own rival measurement of slavery or trafficking or whatever it is in the world. So we've got a little bit of a problem about quality control, and yeah, I'm not really sure how the tip office could work to improve that. And of course, my other bugbear is, I've already mentioned, is the fact that we have very strong, very clear international laws around trafficking at the moment. And I find it, I understand it from a technical level because this is congressionally mandated and all of that kind of stuff. But as an outsider, it's absolutely bizarre that the United States is judging countries on standards created by its lawmakers and not on the standards that those countries have accepted at the international level. That just looks weird from, you know, from outside this country.
That's a very good point. Thank you.
Yeah. Janie is the expert on this, but I will mention one thing that I thought was really interesting way back in 2002 when the tip office, I think, had just opened. They had a model law on their website that was recommended to other countries of the world. So it was written by the Department of State, offered to other countries of the world about how they could best sort of meet the protocol definitions and so forth. And when it was, we pointed out to them that the bar that was set in that model law was much, much, much higher than what Congress had written into law. It disappeared. And you can't find it anymore, except I think I have a hard copy somewhere, which you should always do. You should always save a hard copy. But I think that's sort of, that mentality is still there. It's sort of interesting, you know, the split personality between the Department of State and DHS and other entities within the United States and Congress and so forth about what it is that we're really trying to do and whose responsibility it is. I think it would also be really useful to have more uniformity in terms of who in country is making the in-country assessments on behalf of the Department of State, because my understanding is there's still quite a bit of inconsistency in terms of quality control, as you say, where they're getting their information from, whether it's verifiable, whether it's sort of offered by somebody who has a pony in the race, and so forth.
Thanks. So I don't want to pick on the U.S. government too much, but I am curious how can other actors, whether it be the NGO community, the private sector, militaries, particularly in Afghanistan and in Iraq, as we've seen some of the issues around subcontractors around in military bases, how can they contribute to solutions to these issues, and can they work better together to make meaningful contributions and solutions?
Yeah, I'm actually going to go first only so I can pass it almost straight to you, because it really exposes the narrowness of my focus with states. I've over the last years, I've seen much more involvement of civil society in the issue of trafficking in persons and an attempt to get business on board. I kind of have mixed feelings about this. I always worry that states are looking for anything to get themselves off the hook. And I feel very strongly that we're talking about issues that require states to take action, even if it's about the regulation of industries. And by kind of pushing it off to making it this kind of corporate social responsibility thing and letting the NGO, I think that states, we're perhaps allowing them to get away with too much and to abdicate their responsibility to, for example, regulate the industries within their jurisdiction. So that's my first thought. And my second thought around, I think once again, Janie and Dina have so many more interesting things to say about this than me, but the whole NGO civil society engagement with slavery, trafficking, all of that kind of stuff has been a bit of a mixed blessing. Obviously, it's brought a lot of attention to the issue and at least a superficial level of awareness. But yeah, it's difficult to see how feeling good about feeling bad actually moves into something that is perhaps a little bit more substantial.
Do you think that there's a role for at least the NGO community to hold governments accountable rather than letting them abdicate their responsibilities, but saying you promised, you know, X, Y, and Z to do this and making sure that can NGOs do that or do a better job of
absolutely.
it?
And my background is in human rights, so I think we've seen the power of non-governmental organisations in holding governments to account. But in that, I worry that NGOs are disengaging a bit with governments. Like they're starting to focus on corporations. They focus a lot on themselves. There's, and governments, that they need to actually be pressuring governments. And if a corporation has got exploitation or trafficking or forced labour in its supply chain, this is a matter for governments first and foremost. And this is where I think that non-governmental organisations should be putting their prime attention.
Great, thanks. Professor Haynes?
Yeah, I think the shaming that was done when suits were brought against KBR and Signal and Armor for using federal US dollars to hire through subcontractors, multiple subcontractors, by bringing suit against them, sometimes effectively, sometimes not, I think was really, really useful. Even the lawsuits that didn't go forward for technicalities, I mean, clearly spurred the executive order. And it's probably too early to see how that plays out. I'm a little bit concerned about, again, the level. If you look at a case like KBR, which didn't go forward, but it had 15 subcontractors named in the lawsuit, and the lawyers who are bringing suit, KBR is formerly Halliburton, right? So it's a huge company that made $81 billion in 1 year in Iraq. And the lawyers bringing suit against not just KBR, but their 15 subcontractors in 15 different countries around the world had to find evidence in order to bring that case forward, which couldn't go forward because of retroactivity and extraterritoriality issues. But imagine yourself being a lawyer with the ACLU or Southern Poverty Law Center and trying, or a clinic, and trying to find enough evidence to really lawyer against that. It's impossible, but the fact that they tried, I think, was really important because, again, clearly in an instance like that, US dollars should not be used to hire trafficked persons. And once it's known that that's what's happening, it has to stop. And that's an easy fix, technically. Whether we can really follow the money and see whether subcontractors are insulating the primary contractors or whether it's effective, I think we need to wait a little while to figure that out.
There's a rather damning documentary that Al Jazeera published a little while ago with interviews, secret interviews taped showing subcontractors offering actually money to a representative saying, I will pay you if you hire all these people that have paid us. And
I mean, I worked in Bosnia years ago, and I can name the contractors that were a problem then that are still being utilized always in our contracts. And I don't understand why that can happen. I mean, we have accountability issues all over the place with issues unrelated to trafficking, but also related to trafficking. I mean, the companies, the subcontractors that were named as a problem in Bosnia in 1996, 97, 98 are still receiving the contracts to provide military support in places where we need that sort of military support, and that's troubling.
So I'm going to turn it over to the audience to ask questions. Do we have some floating microphones or working floating microphones? And I can volunteer mine as well if we need some extra. Oh, okay.
No, we're good.
So
We're good.
just in case you need an extra one.
Sorry. Hi, Clara Brillenborg, co-chair of the Women in International Law Group. I had two separate questions. One is you talked about the role of international law in affecting change within your work. Has that change in practical terms, has the existence of a robust system of international law governing these issues been helpful in advocating for change to occur, or have you seen it used as a specific tool or weapon in in governments implementing specific regulations or in lawsuits being brought, even though the nature of these obligations is different. How have you seen the practical impacts of this robust international law system and the existence of these treaties? Is it simply advocacy, or is there more operational, real consequences? On a separate note, I would be very curious to hear a success story. Which country would you highlight as having turned around or significantly improved its approach to trafficking or migrant issues, and specifically what measures did they take? What actions were occurred in order for them to improve that could be used by other countries?
Okay. Were they? Yeah, then you please. Okay, the impact of international law. In a way, I think it's easy to answer this question because before we had a legal framework around trafficking, and I should add that we have the trafficking protocol from 2000, but also what we've had is kind of a crystallization of how how international human rights law applies to trafficking in person, something that wasn't really possible when we didn't have a definition and when those parts of human rights law weren't as strong as they are now. But look, I think the easy answer is that before this, so before the turn of the present century, trafficking was only criminalized in a very, very small number of states. And amongst those, almost all only criminalized trafficking. So now I think it's close to 145 or 150 countries have a specific provisions in their penal code or a separate statute that actually criminalizes trafficking, and to greater or lesser degrees implements the rest of the obligations, at least in law, in the protocol. So, for example, giving kind of minimum protections to victims and ensuring that trafficking is an extraditable offence and all those kinds of things that are in the protocol itself. So I can't imagine what my job would be like if I didn't have that structure of international law, because it's just changed how states think and understand about these things. Now, of course, it's not perfect, because we know that countries can be, especially with the US looking over their shoulders, countries were very quick to do the like to develop a law on trafficking and to ensure that trafficking and related offences were criminalised. And so now, of course, we come to the hard bit. And this is where I think the general task of international law, particularly the difficult areas of international law, which I would include within that group human rights law, refugee law, international humanitarian law. It's a chipping away at attitudes and practices and behaviours that have existed forever. People have been exploiting each other forever. So this is not going to change overnight at all. And I think we'd be naive in the extreme to imagine that we're going to see the fundamental kinds of shifts that are really necessary to eliminate exploitation from human conduct and behaviour. But we've gone some little way. And once again, I feel like I've just, maybe because I have a longer time perspective and perhaps because I'm just more optimistic. Anyway, I feel like we've done, we've taken at least the first steps. And I'm a critic of international law in so many different respects. But I think in this area, international law has served the international community very, very well. And I can't imagine what it would be like without it. Now, your next question was much harder. Is there a success story? Well, for me, the success stories are the countries that keep trying and things don't work and they keep trying again. So there's a group of countries, and they're sort of the ones that maybe you would expect, that have developed a trafficking law and tried to do the right thing and set up special trafficking units, and it didn't really work. So then they changed their law again, and they realized that they wanted to prosecute traffickers, but they weren't getting victims in as witnesses. And this is an extremely difficult crime to investigate and prosecute. If you don't get victim cooperation, you're just not going to get a prosecution. Maybe we can imagine a future where, with proactive investigation techniques and really smart policing, we can do something different. But at the moment, you need victim cooperation, and victims have no incentive, of course, to cooperate. They just want to be left alone, and they just want to have a decent job, and either go home or stay and get a better job. So this has really been an obstacle. So in the countries, the learning countries, you've seen then that they've developed visa regimes. They've developed mechanisms to actually allow victims of trafficking to have some kind of reflection period where they're just given legal and social protection and allowed to figure out what they want to do next and whether they want to cooperate. In these learning countries, you see sometimes even changes in the law around how victims deliver testimony in court so that they don't get re-victimized through the criminal justice process. So, yeah, I think very crudely, we can divide countries up into the learning and the non-learning ones. And no country has, I think, really probably come even close to eliminating trafficking from, particularly because global migration means that people are moving more. The opportunities for exploitation are probably greater than they have been in the past. But we do see, countries that are doing much better than others.
Professor Haynes, did you want to respond?
Just to throw something out, this doesn't answer your question, but it's sort of a question back to everyone. I'm just thinking off the top of my head, but I think that there's a difference between countries that are countries of origin and destination. And I think that, again, this is where I'm making a sweeping comment without having a lot of support. But I think that countries of destination have made strides because the tools and toolbox are there for prosecution. Some have done it better than others. The next step, I think, is countries of origin, not alone, but also with the countries of destination that are the supply chain, basically, for those countries of origin, to start thinking about the harder question, which is prevention in the countries of origin. It's also the more expensive question, potentially. And I think that's sort of where we could focus some attention rather than post hoc after a crime has been committed. What can we do to try to come up with some restitution better than we are, to really solidly get in on prevention throughout the whole chain would be a focus.
Definitely the structural questions of poverty and inequality, much harder to tackle. Anybody else have a question? Up here in the front.
Thank you very much. My question is more about another conference I attended about human trafficking. It was about armed conflict. So I'm wondering what your thoughts are about the whole 3P system and how it kind of falls apart in the context of armed conflict. How do you kind of reconcile any sort of protection, prosecution, prevention at all during an armed conflict situation in terms of human trafficking? Because it kind of seems to exponentially increase in a situation like that. I'm just curious what your thoughts on that might be.
I swear I didn't plant her.
Okay. Yeah, well, gosh, trafficking is just one of many human rights violations that are vulnerability is increased so dramatically. So I don't know if the answers are very different for trafficking as they would be for any other kind of human rights violation. And obviously the capacity to actually deal with trafficking in a holistic way, if we say that holistic is prevention and prosecution and what's the other? Protection? No, that's, oh my goodness, how can I have, prevention, yeah. So these things are almost impossible. So I don't think I have a good answer. We do know well though that situations of conflict exacerbate vulnerability to trafficking, and you see the normal defences against trafficking, whether these are legal or normative or social or cultural, breaking down very quickly. Would you like?
Yeah, I think I said this at the conference that you were at, or alluded to it at least. I think I would like to know much more empirically about what actually goes on, because it's easy to make really logical assumptions about trafficking happening during times of conflict where there are political and legal and economic vacuums, and people are easy to collect because they're in refugee camps or centers. Actually, most of them are urban, but still they're vulnerable. But the reason I want to know more empirically is it's not that I doubt that it's happening. It's that I think there may be different things happening that we need to fight. So, for example, in the early days of the Syrian conflict, people were talking about fleeing because they had heard that people were being threatened with trafficking. That's a problem, but that's a different problem, right? The threat of the thing is a different problem to tackle, and it's a different crime than the actual thing happening. So from a prevention and protection perspective, the humanitarian community want to stop the thing from happening, we need to talk about the threats being used to forcibly, for forcible migration. And we've seen this in Bosnia and other places as well, right? People who want people to leave have become very astute at saying the things that trigger people to flee, that trigger your most horrifying fears, you know, if you have a family, for example. So I think we really would benefit from knowing more about what actually is happening. The same thing again in Syria with the forced marriage. Again, the extent to which it's been happening, has it been spurred because of threats and rumors of people being trafficked or abducted, and so a forced marriage is the better solution? We would benefit from knowing more about what happens in humanitarian crises.
Sounds like a great research paper.
Exactly.
Any other questions? Up here in front? Here, I'll just.
Thank you. Well, my name's Neville Naidu. I'm actually a prosecutor and attorney from South Africa. I know you would be familiar, Professor Haynes, with the South African system, but we recently implemented a trafficking bill in accordance with our signatory to the trafficking protocol. And something that was important for me in the bill being introduced is that previously we used to have trafficking included in terms of our legislation in a very small part of our Sexual Offences Act. And of course, now the shift has been that it's more inclusive with the new bill. What I found that is very difficult, and it's something that was raised earlier, which is compensation to the victims. And for them to feel that there's some way of being able to get back this money that they've worked for, essentially. And the massive hindrance that we find is that, as you mentioned earlier as well, successful prosecutions lead to more likely than not successful claims for compensation. And my question would be, I know that in your book, Dr. Gallagher, you talk about a new arsenal that we need to combat this contemporary exploitation. Do you believe that exploitation can be combated with more of an emphasis on the financial impacts and how victims can more easily use the criminal justice system to access those funds?
Yeah, look, I think it's a great question, and maybe this is sort of the second or the third generation of anti-trafficking work and advocacy. We sort of have the laws and we have the people understanding what it's about and making mistakes and everything. But now in a number of countries, we're actually seeing some willingness to take this next step, which is to go after the assets of exploiters, and in many cases to then return those assets, hopefully to a fund that would then support victims of trafficking. And this is an interesting aspect related to the evolution of international law around trafficking, because a lot of things when the Trafficking Protocol was developed in 2000 were not accepted by states. So I was representing the UN High Commissioner for Human Rights, and we were pushing for recognition of the right to a remedy in the Trafficking Protocol, and states basically said no, not going to happen. We were also pushing for a provision that would prevent states, or at least discourage them, from prosecuting for status-related offences. So making sure that victims of trafficking weren't being prosecuted for, I don't know, working illegally or working in prostitution or immigration offences and things like that. Now, the interesting thing is, over the last 14 years, these two principles have really, I believe, very much crystallized into international legal obligations. It's very clear that states, and they're starting to recognize it. We see it in General Assembly resolutions, and we see it in the work of the states parties to the Trafficking Protocol itself, saying that they recognize the right of victims to remedies. Now, once again, we get the law and we get the principle, and then we get the reality. And I think that states are actually finding it really hard to figure out how to do that. A number of countries that I work with say, well, just go under normal criminal injuries compensation, which a number of countries have, and it's a crime, and then they can get whatever. Most of these schemes are really insufficiently funded, and they're not actually structured to compensate for the kinds of harms, the lost wages and everything that many victims of trafficking actually experience. So there's a push now for states to set up separate dedicated funds. I know a number of countries have actually done that. It could happen, I guess, in South Africa with the right kind of pushing. For sure, countries that have started to work on the financial aspects of the crime have, like the UK, for example, has managed to find millions and tens of millions, I think hundreds of millions of dollars, and to actually recover it. So now there are sort of ways of they're looking at ways of getting at least some of that back to victims. So this is, I think, for speaking to a prosecutor, I think this is a very valuable path for criminal justice agencies to actually pursue, and one that hasn't been explored to date. I know that the US Treasury is at the moment looking exactly at that. So yeah, let's hope. But perhaps the first step, the recognition that victims of trafficking actually have a right to a remedy and a right to access that remedy, which means, for example, legal advice and everything that goes with making that right actually real, then that's an important first step.
I would just be curious to know from the prosecutors listening here from this country and from others, whether the victim is involved in sex trafficking or labor makes a difference in the willingness of the prosecutors to pursue wage compensation. Because I know in the United States that's a really big problem, and it's sort of it's not even open for discussion to think about wage compensation for sex trafficking, although other types of compensation would be on the table. So I'm curious in other countries whether that's been an issue as well, whether it'd be easier for you to go for back wages or wage compensation in a labor case than a sex trafficking case.
Janie, did you want to add something?
I just wanted to give a shout out to a report that the Pro Bono Human Trafficking Legal Resource Center, I'm maybe getting the name of the organization wrong, Human Trafficking Pro Bono Legal Resource Center, I think, started by Martina Vandenberg, in collaboration with the law firm Wilmer Hale, just came out with an astounding report on restitution in the United States. And so this sort of speaks to your question and also Dina's comment and question. And in that report, they found that because under the U.S., so just backing up, under U.S. law, there is a right, a right to restitution. It's supposed to be mandatory, right? Any victim of trafficking has a right to restitution, and prosecutors are supposed to ask for restitution. This report found that only 36% of cases that were prosecuted actually involved restitution to the victims. And surprisingly, to the extent that restitution was granted, you saw more money coming out for labor, non-sex sector trafficking cases than for sex sector trafficking cases. Which should not be the case, because the way that the law is set up in trying to, so Dina had mentioned that one of the concerns that people have about restitution in the sex trafficking context is that it's hard to put a dollar sign on how much are you going to value that labor or service or whatever you want to call that exploitation. But the way that the U.S. law is set up is it's not just, they have a provision that says basically that the restitution should be in the amount, the value of the services provided. So if you're dealing with a situation outside of the sex sector, for instance, you might look at prevailing wage standards to figure out, per hour of services or exploitation worked, you calculate it according to prevailing wage. But the law also provides a provision that says, if you can't calculate based on prevailing wage, you calculate it based on how much those services were worth to the defendant, right? So the sex trafficked person who may be earning $1,000 a day for the trafficker, if you calculate it that way, the restitution order should be much, much higher for the sex context than in the non-sex sector context. But it's actually the reverse as it plays out in the United States. And so so that's something to sort of chew on, I think. I recently heard Martina Vandenberg speak at a conference, and she talked about how in the Netherlands, they have and the problem with restitution in the US is that, one, prosecutors aren't necessarily pursuing restitution, even though it's supposed to be mandatory. But often it's hard to get money out of the defendants, right? It's hard to find the assets. In the Netherlands, apparently you have a right to restitution, and if the government cannot get the assets from the defendant, the Dutch government pays the victim the restitution, and then they will then go and try to seize the assets, however long it takes the government. But in the meantime, the victim does get the restitution. So that's a pretty phenomenal development. It'd be great if South Africa could follow. I had a related question actually for Anne and Dina. So Anne, you were talking about on the restitution front, this idea of getting assets from the defendants and creating sort of a fund, right, that would pay out to victims compensation. One issue that was raised in the context of this discussion at this conference I was just at about restitution was that Martina Vandenberg had raised this question about, or raised the issue of how, at least in the United States, we have laws that require forfeiture of the defendant's profits from the trafficking. And in forfeiture cases, that money goes to a state compensation, theoretically at least, goes to a state compensation fund. And that the push now from advocates in the United States is to actually get rid of forfeiture requirements, because it actually undercuts victims' ability to get restitution, because the money's going to the state, not directly to the victim. I mean, victims could have access to the money maybe down the line, but it requires them to jump all these bureaucratic hurdles. So it's a better vehicle if you were to just require mandatory restitution and not have a forfeiture requirement. And I'm wondering if you've seen that play out in other countries in a way where forfeiture actually works to the detriment of victims trying to seek restitution.
Okay, well, the first thing is that the Dutch model that you set out, that's sort of emerging as the gold standard. That's what countries are being pushed towards. The Australian government is being pushed very strongly towards setting up a compensation fund funded by the government that would ensure that every victim of trafficking, including those that don't go through the court process, because not every prosecution requires every victim, they can actually get compensation for the injuries that they've suffered and for lost wages, etc. Yeah, on the issue of forfeiture, it sounds to me like it's a coordination problem. I don't know why I can't see the logic in getting rid of a law that's generally applicable to the criminal justice system, a law that applies to many crimes, of forfeiture just because you can't get it right on trafficking. So I think that it seems like kind of a drastic solution to a problem that that should actually be amenable to resolution in a much more straightforward way.
Let's take one more question, and then I want to give you guys enough time to enjoy the reception and have some one-on-one time to ask our panelists questions.
Yeah. No, I had a comment in connection with restitution. I had a conversation with the Department of Labor, and for what I know, and I might not be precise enough, when they have an inspection, when they detect cases of labor trafficking, they start a case and they have to pay restitution and wages to the victims. And one of the difficulties they were having, and that's what they mentioned, is they were having a hard time by the time the case was adjudicated to locate the victims of trafficking. And they were trying to establish an office in Mexico and in other countries trying to locate those victims. So there's money at the Department of Labor that is not given to anybody and should be given to people. No? So,
Is anybody here from the Department of Labor?
Was there one last question?
Can I just say one thing? And this doesn't answer your question, but the Department of Labor certifies middlemen in the United States. We haven't talked about middlemen, but I think that's one of the big problems we have. They certify middlemen who bring people in through visas, right? So not everybody is an illegal alien who gets trafficked. And there's a big problem with these Department of Labor certified middlemen who blacklist people for complaining about things. So I think I've, in the last couple of years, heard the Department of Labor become very interested in this. I think that would be interesting. There are a couple of NGOs doing in Mexico what you said the Department of Labor is attempting to do. I'd like to hear more about that.
I think, the issue with employment agents is also an issue that's been discussed with labor trafficking internationally.
Oh, definitely. It's becoming much more of an issue.
All right, I think there was a question in the back. Oh.
I'm curious about one of the main avenues of moving people being the maritime industry. And I'm admittedly ignorant on maritime law and whether it remotely covers anything having to do with trafficking. But I was wondering if you could speak about if there is any sort of overlap there, or if the two sort of methods of law could work together, and what kind of complications there might be for flagged ships and things like that, and how the maritime industry is sort of playing into the issue of trafficking and what laws might be applicable.
Okay, well, I don't really have a satisfactory answer to that, at least for myself. But when I did the trafficking book, so that was in 2010, there's nothing in there on law of the sea, or really nothing even on extraterritorial application of human rights obligations. Now, the smuggling book, written 3 or 4 years later, has huge chapters just on those issues. And I think that if I'd gone, if I go back and review another addition to the trafficking book, that would have to come into it, because we've only started to realize, for example, over the last couple of years, the extent to which the world's oceans and regulation of the world's oceans actually facilitate huge exploitation, particularly what I'm working on, which is mostly in relation to fishing and the fishing industry. I was in New Zealand earlier this year, where the most complicated situations arise, where New Zealand government gives fishing licenses to Korean flagged vessels that are just outside, like they're in New Zealand's exclusive economic zone, so not in their territorial seas. And these Korean flagged vessels are full of Indonesians, and I think they're mostly Indonesians, ruthlessly exploited, absolute slave labor. But the jurisdictional issues around that are so incredibly complex. At least 3 countries and sometimes 4 countries are involved, and then all of these maritime zones. So it's extremely complicated. And of course, you see it in migrant smuggling all the time, to where does a state's human rights obligations begin and end? Can a state intercept a migrant smuggling vessel on the high seas and turn it around? Does it make any difference if the people on board are actually being headed for or are being subject to exploitation? Yeah, so it's extremely difficult, and I think that under the weight of these contemporary challenges, international law of the sea in particular is creaking very loudly.
Any last thoughts? Okay, please help me give a huge round of applause and thanks to our speakers. And I hope you all join us in the back. We've got some refreshments and drinks, and I'm sure the panelists would welcome any additional questions you have.
I'm just going to leave. I've got these books, but I've also got the Anti-Trafficking Review, which can be downloaded. This is the Trafficking